Hello, I'm Nicole Hartnett, and I'm a managing attorney with Corporate Immigration Partners. And I'm here to discuss an important update on the H-1B visa in partnership with Envoy Global. On October 20th, 2025, USCIS issued further guidance for implementation of the presidential proclamation titled Restriction on Entry of Certain Non-Immigrant Workers. This update outlines who is subject to the newly required $100,000 fee, as well as how and when payment must be submitted and the criteria for requesting an exemption. The effective date of the fee is September 21st, 2025 at 12:01 a.m. Eastern Time. According to USCIS, cases filed after that date in the following situations will be subject to the fee if they meet any of the following conditions. 1, the beneficiary of the petition is outside the United States and does not have a valid H-1B visa. 2, the petition requests consular notification rather than a change, extension, or amendment of status within the United States, even if the beneficiary is in the United States at the time when the petition is filed. 3rd, the petition requests a change, extension, or amendment of status within the United States, but USCIS determines that the beneficiary is not eligible for the requested change, extension, or amendment. USCIS has also specifically stated that the proclamation does not apply in these situations. 1, where the beneficiary already held a valid visa as of the effective date, or the H-1B petition was filed before the effective date of the proclamation, or the petition requests a change, extension, or amendment of status within the United States, and USCIS determines that the beneficiary is eligible for the requested change, extension, or amendment. Now, as far as how this will impact employees registered in the fiscal year 2027 H-1B lottery to take place in March 2026, as long as the employee is in the United States in valid non-immigrant status, such as F1, L1, TN, etc., when the petition is filed, and the petition is filed as a change of status rather than consular processing, the fee will not apply to them. It will apply in situations where the employee is outside the U.S. at the time that the petition is filed, which is often the case for companies who register people in the lottery who live and work abroad. The guidance also clarifies that beneficiaries who are not subject to the fee will not be required to pay the fee if they depart the United States and apply for an H-1B visa to be able to re-enter the country. With this information in mind, it is more important than ever to ensure that employees in H-1B status do not make material changes in their employment until an H-1B amendment has been filed. Most commonly, this includes changes in work location and changes in job duties. Failure to remain in compliance with the terms of an H-1B approval or other status that the employee holds, even unknowingly, could result in an employee becoming subject to the $100,000 fee when it comes time to extend or amend their H-1B status. The guidance from USCIS also states that exemptions to the $100,000 fee will be granted only in extraordinarily rare circumstances, and only if the Secretary of Homeland Security determines that A, the beneficiary's presence in the United States is in the national interest, B, no U.S. worker is available to fill the same job, C, the beneficiary does not pose a threat to the United States, and D, requiring payment of the fee would significantly undermine U.S. interests. USCIS has not provided guidance on what types of documentation may be considered satisfactory. Finally, we have learned how and when to pay this $100,000 fee. Effective September 21st, 2025 at 12:01 a.m. Eastern, all new H-1B petitions subject to the proclamation must include a $100,000 payment submitted electronically via pay.gov, and petitioners must use the designated form titled H-1B Visa Payment to Remove Restriction. The payment must be completed prior to filing the H-1B petition. Petitioners should retain the payment confirmation receipt for submission. Petitioners must include one of the following with the initial petition submission: a copy of the payment confirmation from pay.gov or evidence of an approved exception from the Secretary of Homeland Security. Petitions filed without the required documentation will be denied without further review. According to the pay.gov form, if USCIS does not approve a petition, it will issue a full refund. To ensure proper reimbursement, petitioners must enter banking information in the designated financial section and ensure it matches the payment details submitted. 2 lawsuits have been filed in federal court seeking to enjoin enforcement of the $100,000 fee, which may result in modifications to the above criteria or to the $100,000 fee being blocked altogether. As always, this is a rapidly evolving situation. If you have questions, I recommend you contact your immigration legal counsel. Be sure to head to envoyglobal.com for the latest updates regarding the H-1B. Thank you.